This is April 8th. Tonight we are going to review a very rough draft of what we'll eventually send to the town council. It is a rough draft because the council bundled 14 amendments, some 45 years of changes in one, and we were only given 45 days to do that. We've done what we can, and we'll send back what we can. To just review some things, and most people are familiar faces, but if there are new people, people have been coming up to me, and I'm sure other planning board members have been approached and asking us, please don't do this, don't pass this. I'd like to reiterate, we don't have the power to stop this or to implement it. We just send recommendations. In this case, we were not asked for recommendations. The instructions for the town council were very narrow and very defined. We are to basically give a thumbs up or thumbs down to the package, and they will implement it from there. I would again reiterate, and people have been extremely respectful, but I did go to last night's planning board, sorry, I'm very tired and I'm really burnt out over this. I went to last night's town council meeting and things got a little emotional. I ask you to please take a deep breath, just state your case. We don't have a ton of people, so I'll give you plenty of time to talk. Again, if you are in agreement with somebody who's already spoken, please state that fact. If you have something new to add, please add it. But it just provides more time for other people to speak. That is what it is for introductions. I have some procedural questions to ask legal. Again, for those who have not been here, there are two types of laws, content law and procedural laws. Content laws, by the Enabling Act, allow cities and towns to shape those state laws. It's powers that are vested to the states from the federal government and from the states to cities and towns. And you'll hear from time to time in this mentioning of the Enabling Act. It has been championed by some people that we absolutely cannot change a single word of what the state puts down. Both our councils that represent us here, that were hired by the town council, have said that's not true. I spent most of the day calling people at the State House and got a lawyer who said, and I quote, "Anybody tells you you can't doesn't know what they're talking about." And in fact, at last night's town council meeting, they utilized the Enabling Act to pass a tax. So they say one thing, they do another. So there are some things that we will specifically talk about, but that was not within our scope, that is not within our power, and that was not in the instructions for us to change anything. Okay? I have two questions of procedural law. One, we were given 45 days, the town council was given 65 days. Now, by simply setting the hearing date, does that qualify them that they've satisfied the 65 days?
Well, they'd have to convene that hearing. It seems like that's going to happen, yes.
Okay. So my question is this. We were handed that binder. Some people have said 200 pages, some 300, 400, but it's a few hundred pages. My understanding of state law, and it is not unique to this state, the procedures binding notification of the public of hearings is very strict and very defined. There are 3 publications before the meeting. The first publication must be the entirety of what is being reviewed. And then the next 2 can be synopsises of that entirety. Am I correct in that?
So I'd put it this way, having dealt with this in a smaller context, not the binder that you point to, whenever I've been asked as to how to adequately inform the public of whether it's an ordinance amendment or what have you, my opinion's always been print the whole thing. Maybe that's belt and suspenders, maybe that's out of an abundance of caution. That's how I always recommend it's passed. What is going to happen here is unknown to me, but that would be my personal practice.
Yeah, I think it's unknown to all of us, and this is why I'm asking these things. So if it is not properly posted, that can be appealed, correct? I'm not sure if appealed is the correct word.
Notice is a prerequisite, and an adequate notice, proper legal notice, is a prerequisite to the validity of an ordinance.
Okay. So if someone challenges the validity of that first posting for lack of completeness, whether it was edited for money savings or space savings or whatever, but it was edited or edited in any other way, and it is challenged, does the process stop? And more specifically, how does it affect that 65-day window?
So I can't tell you that I've seen a challenge before an ordinance was passed. I can't tell you I've seen a challenge in the middle.
So this isn't a challenge to the ordinance. This is a challenge
Challenge to
to
notice.
the appropriateness of the posting.
Right, and I don't think I've seen a challenge as to notice that occurs before the ordinance is passed,
Okay.
meaning in the middle of the process. I don't think I've seen that.
All right? Is that excluded from happening?
No, you could go to, it's up to a judge to decide that.
Okay. And then what is the process to appeal if it is not properly posted?
It's codified by statute in the zoning ordinance. I don't have it in front of me, but it's in
That's fine.
the zoning enabling act.
That's fine. I'm not expecting you to.
Sure.
If it is found to be in violation of posting, what happens to the process? Does it start over? Does the 65-day clock still tick? Does it, yeah, it was bad, but it just continues?
Absent an order from the court stopping the process would go on.
Okay.
So Nick, what you're saying is someone would essentially have to go to court and try to file an injunction?
Yes.
To stop, right?
Yeah, that was
And
my next question.
that was in the process, right? And just on, Mark, on your opening comments, I just want to be clear.
Yeah.
While there may be 400 pages in the book, the actual things that get noticed are not the supporting materials that we've provided in terms of prior.
Yeah, and I was going to get to that.
Yeah, okay.
I was going to get to that. I want to clarify that, but I want to understand this. All right. So if it goes to court and there is an injunction, the process stops. Does the 65-day clock stop?
Again, this is somewhat uncharted with, and I told you myself, I haven't seen a challenge in the middle of the process.
Right.
I would expect that question, timeline, to be taken up by a Superior Court justice if and when injunctive relief were addressed.
Okay. All right. Another procedure. This was drafted as a whole package and sent to us as a whole package. And both you and Attorney Craven have been very specific, and both of you have been fantastically helpful. One, that we had to follow the instructions of the town council, which were very narrow and very defined. And two, that we needed to make a decision on the whole. Last night, the town council announced that they were actually going to break it up and make decisions on the individual. Are they not, as they initiated this, they passed this down, aren't they obligated to the same procedural law that we are?
So I think it's more of practical advice on how, for our purposes, how to deal with what you were tasked to deal with. I think the only way at the time, on a short time frame with a binder of material, was to do it at once. And then in your report, which we have a draft of tonight, to address those individually. How the town council is going to proceed, I don't know. Is there a framework in place for how to proceed with 14 amendments? No, there isn't. So I don't have a crystal ball. I don't know how they're going to proceed. We proceeded in a manner, I think the only manner, that made sense given the time frame for us.
Okay, thank you. Any other questions on procedure? Okay. At this point in time, I'll ask for the roll.
Here.
Here.
Still here.
Here.
Yeah, I feel the same, haven't left. Okay. Thank you. All right, at this point in time, I want to state that we have submitted a rough draft to the staff, and they have reviewed it. They've sent it back to us, and I just want to thank everybody involved with the amount of mass, and that's all you can call this, mass. It was a brilliant strategy on the town council's part. The more and more I get into this, the more it was a begrudgingly compliment in the beginning, and I got to tell you, it was an excellent process to jam a package through. But people have done yeoman's work, and I am very, very proud to be part of this board and honored to be part of this staff. So thank you very much. At that, I'm going to turn this over to the staff.
Hi, good evening, Jill Saban.